you're having a great day today. So today we're talking about labor relations and collective bargaining. This chapter provides an overview of key labor laws. It discusses the basic provisions of the National Labor Relations Act of 1935, the Taft-Hartley Act of 1947, and the Fair Labor Standards Act of 1938. The chapter then presents information about unions in sport and collective bargaining. Most unionized workforces in sport involve professional athletes, some staff, interscholastic and intercollegiate athletes, or facility management personnel. In collective bargaining negotiations, employees through their union and employers through a management team negotiate over mandatory subjects of bargaining, such as hours, wages, and terms and conditions of employment, resulting in a contract, the collective bargaining agreement. In sport, the critical components of the collective bargaining agreement usually include salaries, pensions, insurance, free agency, the method for resolving disputes, or arbitration, salary arbitration, discipline, drug testing, and salary caps. Unique to the professional athletes union is the fact that the employee athletes can have separate individual contracts that bind them to their club. But they are also parties through their players' associations to collective bargaining agreements. Information in this chapter is critical to managers involved in unionized industry segments because it is key to a successful labor relationship with employees. So in the management context, again, looking at union organizing, and that basically is going to relate to National Labor Relations Act. And also looks at unfair labor practices. Of course, workplace discrimination is going to look at the National Labor Relations Act and duty of fair representation. Those are all looking at the National Labor Relations Act. So with labor laws, they exist on both the state and federal levels. With state laws, you're looking at public entities such as university athletic departments versus the federal laws, which are applied to private employers engaged in business involving interstate commerce. Some examples of labor law legislation. Really, labor law has evolved from federal statutes such as the Sherman Act of 1890 that prohibit contracts that restrain trade or commerce. The theory of antitrust law prevents groups of competitors from reducing competition in the market. The Clayton Act of 1914 created a statutory labor exemption from antitrust laws by limiting the use of antitrust laws against labor unions. And there are a couple of acts, the National Labor Relations Act of 1935. We're going to talk more about that in just a moment, and the Taft-Hartley Act of 1947. Now, the National Labor Relations Act sets forth employee rights with private employers, including the right to negotiate with an employer over hours, wages, and terms and conditions of employment. It also encourages collective bargaining and protects exercise by workers for full freedom of association, self-organization, and designation of representatives of their own choosing for the purpose of negotiating the terms and conditions of their employment or other mutual aid or protection through unionizing. So that collective bargaining portion really helps to encourage the unionizing and protection of their rights. So it also created the National Labor Relations Board, and that has helped in negotiations as well. Now, the intent of collective bargaining is really to encourage workplace harmony with employers and employees. Section 8 is one that it prohibits private employers and labor organizations from engaging in certain types of activities called unfair labor practices. These unfair labor practices include interfering with or restraining or coercing employees in the exercise of their rights, of dominating or interfering with the formation or administration of a labor organization, It also includes discriminating against employees in hiring, tenure, or conditions of employment to discourage labor organizations' membership. As well, it includes discharging or discriminating against an employee who files an unfair labor practice charge or testifies before the NLRB, and also refusing to collectively bargain. Now, primary activities of the NLRB are to administer labor laws in the United States. They do this by conducting secret ballot union elections for certification and decertification. We'll talk more about that in just a little bit. And prevent and remedy unfair labor practices committed by management or unions. Now, the Taft-Hartley Act is one that it amended the NLRA to balance the employee and employer relationship. So it, with the NLRA, it gives an awful lot of power to the employee. The NLRB kind of puts it back and gives more of a balance to the employer. So with that, it also gave employees the right to not join or assist in unionization. It also prohibited unions from discriminating against non-union employees. And it grants employers the right to engage in lockouts from discriminating against an employee on the basis of union membership. Now, labor relations applied to professional sport. Here, the labor movement took hold in the sport industry in the late 1960s and early 1970s. There were earlier attempts that were minimally successful. One of those attempts was the American League of Professional Baseball Clubs and the Association of National Baseball League of Umpires in 1969. Now, professional sport labor unions, virtually all major league teams are unionized. Most of them are athletes, not necessarily coaches or front office staff. The issues that they deal with typically are in collective bargaining negotiations they have very short careers, typically at an average of 3 years. And with that, there's very little job security involved with that. So they try in these negotiations, in these collective bargaining negotiations, to get the best deal possible. And with that in mind, that there's only going to be about 3 or more years, you try to get the best wages and working conditions possible. Now, there is quite a bit of disparity in talent and salaries. So your superstars versus those who are holding up the end of the line. Most player associations are national versus local employee bargaining units. Now, with professional sport labor unions, again, this typically involves your athletes, but there are very few white-collar workers in unions. There's also a lot of high turnover in front office and coaching positions. Very rare that you'll see like a Coach Popovich that's in there for 25 years or more. There's intense competition for jobs, and people might not be open to working together in a democratic union organizing movement. So organizing front office staff or coaches on a national multi-employer level is really challenging. Now, employee rights, the National Labor Relations Act, Section 7, basically says that you have a right to join or assist unions. They also have the right to engage in collective bargaining and the right to engage in concerted activity for one's own mutual aid and protection. These rights are guaranteed that workers can choose to join unions. Now, there is a certification process that they have to go through when forming a union as an appropriate bargaining unit. So with that, they have to certify the workers. This brings stability to the collective bargaining aspect. And it also helps to facilitate that agreement between the parties. Usually what they look at is a community of interests. So they look at the needs and goals involved in the bargaining process. They look at commonality of supervision, commonality of personnel policies and work rules, as well as shared work areas and similarity of job duties and working conditions. They also look at the similarity of methods for evaluation and in pay and benefits, and integration and interdependence of operations, as well as the history of collective bargaining between the parties. And then the union is designated as the appropriate bargaining unit and is certified as the exclusive bargaining representative for employees. Now, duty to engage in collective bargaining. Once a union is in existence, management must engage in collective bargaining over mandatory subjects or risk being charged with unfair labor practice. Some of the mandatory subjects for good faith bargaining are hours, wages, and terms and conditions of employment. One of the permissive subjects that management is not obligated to negotiate on, and basically what this says is that there's an impasse, a stalemate in negotiations, and oftentimes what happens with this is that it will lead to a lockout. So you have mandatory subjects and then permissive subjects. Now, there is a duty of fair representation. Basically, this is that unions must represent all employees in a bargaining union fairly. There are no arbitrary, bad faith, hostile, or discriminatory actions. Otherwise, an unfair labor practice could be called under Section 8 of the NLRA. Now, concerted activity for the workers, basically this says that they have the right to engage in concerted activity, giving employees the right to strike, picket, or work slowdown, whatever it is, for better economic or working condition. So it provides protection for the workers. For management, this typically means a lockout or temporary stoppage of work. And basically, management has the right to engage in concerted activity in the form of a lockout. This lockout can be something that can be a defensive move or an offensive move used to pressure the union into accepting terms in an agreement favorable to the employer. Some unfair labor practices. One of those would be employer retaliation for union activity. And this would be as an unfair labor practice for an employer to interfere with, restrain, or coerce employees who are engaged in union activity. It could also be unfair to discriminate against employees for supporting the union. There's typically a test that requires that an employee show that union activities were a motivating factor in firing. And then what happens is that burden shifts to the employer to prove that the employee would have been fired if he had not been engaged in union activities. Other unfair labor practices are a duty to bargain in good faith over hours, wages, and terms and conditions of employment, and both sides have a duty in that particular aspect. And then along with that, there are injunctions, and the injunctions would be when unfair labor practice is alleged, attorneys may seek a court order or an injunction to stop the employer from committing the unfair labor practice. So you have to have these three things with an unfair labor practice. With collective bargaining, really the union's goal is to negotiate a contract with management containing mandatory subjects. This process tends to favor compromise between the two sides. Now, collective bargaining in professional sports, looking at labor and antitrust law, basically it addresses negotiations over policies that are restrictive to the players, such as drafts, salary caps, and limits on free agency. So, do restrictive policies violate antitrust laws? With collective bargaining process, it shields these practices from antitrust liability. The collective bargaining agreements, basically it's a contract that represents the culmination of collective bargaining negotiations. The collective bargaining relationship is one that is ongoing. Each side has the right to convince the other side to come back to the bargaining table. And you can see that there is, the NFL had a collective bargaining agreement in August of 2011. You can check that out on your own. Here are some provisions in professional sports collective bargaining agreements. Salary caps are, of course, one of those provisions, and we'll talk a little bit about that. With that, you can see there are some hour provisions as far as training camp is concerned, and spring training. There are some terms and conditions of employment. One of those, of course, that there can be some grievance arbitration if there's an injury or medical or labor grievance. Minimum salaries are another thing that they can negotiate on, as well as the season schedule and free agency. So all of these are provisions that can be discussed in the collective bargaining agreement. Now, arbitration disputes arise in the collective bargaining relationship and are resolved in arbitration, which is a process in which disputing parties hire a neutral third party to render a decision that is final and binding. There are actually two types. There's rights arbitration, which is an interpretation or application of a contract, and disputes over the interpretation or application of the contract, they're discussed and a decision is rendered. There's also interest arbitration, which disputes over the terms of a contract, such as salary arbitration. Sides must agree in the collective bargaining. A court can overturn a decision only when an arbitrator has abused their discretion or exceeded their scope of authority. So really with arbitration, it helps with that collective bargaining process, and it has final ruling unless the arbitrator was considered to be, they abused their discretion or exceeded their scope of authority. Steps for resolving disputes. Number one, they start out in employees discussing a grievance with the union rep or steward, or reports it directly to a supervisor. The next step, if the union representative and the employee agree the grievance has merit, they submit a formal written grievance. And then thirdly, the union representative and a management representative sit down, attempt to resolve the grievance. From there, the grievance may be heard before a committee to assist the two sides in resolving the dispute. And then last, an arbitration hearing is held and an independent arbitrator or panel of arbitrators renders a decision. Now, with salary arbitration in professional sport, really what you're doing is determining a player's worth. And in that, they consider the player's eligibility, the process itself, and the criteria for judging a player's worth. So in Major League Baseball, basically what they do is they choose a midpoint between two different offers and determine if the player is worth more or less than that midpoint. Players with at least 3 but fewer than 6 years of experience, for example. In the National Hockey League, they choose either of 2 offers or an amount between the two, and players are eligible for 4 years. So those are kind of the negotiation areas that they go through. Discipline. Most collective bargaining agreements have at least one provision devoted to discipline. They are intertwined with the grievance arbitration, which challenges disciplinary action. The just cause clause refers to a level of scrutiny used to evaluate the level of discipline and sets limits on an employer's authority. Now, another means of negotiation is drug testing. And basically this covers substances of abuse, such as recreational drugs and performance enhancers. Drug and alcohol testing is a mandatory subject for bargaining. The goal is really to negotiate fair provisions in privacy rights, confidentiality, results, medical concerns arising from the testing, and determinations of which drugs to test for. There are some educational and rehabilitative components included in the collective bargaining agreement. Now, salary caps. Your collective bargaining over compensation encompasses all of the wage and benefit provisions. The CBA allows players to gain leverage and greater proportion of the pool of revenues as owner revenues have increased through media and stadium growth. So salary caps were adopted by the NBA in 1984. They cannot be unilaterally imposed and must be negotiated with the players. Typically, there is a team salary cap. Then they also look for caps for particular groups, such as rookies. There are capologists, which are specialized financial experts. And basically, they calculate the aggregate league revenues as defined in the CBA. The players receive a percentage of those revenues, and the number of clubs in the league divides that number, and therefore you're able to get the team salary cap. Now, there is also some competitive advantage strategies with labor relations in regards to collective bargaining. You must have a working knowledge of the labor laws. You must also strive to understand and abide by processes, procedures, and rules set forth in a CBA. And ask legal counsel to guide you through the collective bargaining process and related employment decisions. Make sure to ensure that your decisions are in line with your organization's labor agreements. So there's also individual versus collective bargaining, and this is where employee athletes individually bargain power and contracts that bind them to their employer clubs. There's also parties to collective bargaining agreements through their players association. Now, the CBA takes precedence over any individual or party bargaining agreements. And something that's come up just recently with the concussion issues are rights of retired players. What is the duty of a players' union to retired players? Is it something that their duty is to market the likeness of a retired player, to help players with injuries and health concerns? When really, most of the time their focus is on current players. And really the only way for retirees to seek relief is through the courts, which is what we're hearing and seeing now with the concussion issues going on. So what do you think about Players Association collective bargaining and salary negotiations for professional athletes? Does hearing about a baseball player's $28 million salary make a difference to your opinion? How about a rookie in WNBA who earns $36,000? So this concludes our discussion today. I look forward to hearing more from you in the discussion, and I'll talk to you soon.